Hello, everyone. Good evening, if it's evening by you. Welcome to our webinar. Appreciate y'all joining us and waiting for a few minutes as we were dealing through some tech stuff. So appreciate y'all hanging in there. Welcome. Amazing. So as we have folks trickle in, I would love if folks are able to maybe share in the chat, if they are able to use the webinar chat, where you're calling in from. If folks want to drop in the chat your name, where you're calling in from, we'd love to see if we have folks from all over. And wait another minute or two to get started. Hi, everyone. Thanks for joining. Yeah, awesome. Thanks for modeling. Yeah, share names, where y'all calling in from. If you're with OCA, share maybe your OCA chapter. Cool, we got folks from all over, Vegas, New York, California, Virginia in the house. Milwaukee, Wisconsin, we got Washington. Awesome. I love to see members from all over. Okay. So since we had a bit of a delayed start, I think we can dive right into it and at least share with about what we're going to be going into tonight, introductions, and we'll have more friends joining us. But to kick us off, I'm your moderator for tonight. My name is Brianna Sia. I also go by Bree, she, her pronouns, and I'm the Vice President of Public Affairs with OCA National. So I have the honor of serving with Roland on the Executive Council, where we get to work with chapters all over the country, as well as work with OCA National Center. As VP of Public Affairs, I get to advise the team on our communication strategy, as well as our important policy positions that we are taking on issues that matter to our OCA community members. So tonight, we're going to be focusing on a really timely and important topic that's at the crux of who is an American. And how are we talking about these fundamental rights like birthright citizenship, right? That is currently being challenged by this administration. And we're really going to have an exciting conversation with an amazing advocate like Roland. And I'm curious what comes up for y'all as we talk about birthright citizenship. So if you're joining us tonight, you know that tonight we're going to be exploring the legal and constitutional foundations of birthright citizenship in the United States, alongside current challenges and litigation. And helping us pull together the program is Jordan, our awesome intern. Jordan is a intern with OCA National, a junior at Washington University in St. Louis, pursuing a Bachelor of Arts in American Culture Studies with minors in Asian American Studies and Legal Studies, and is our policy intern for the fall. So before I kick it to you, Jordan, to lay out kind of what we're up against and going into framing the conversation. For tonight, everyone, we will be having time for Q&A, so please feel free to continue prepping those and put them in the chat so we can monitor it. We're going to first start the presentation, and then we're going to have some facilitated discussion between myself and with Roland, who I'll introduce in just a minute, and then we'll have time again for Q&A, so please feel free to get those ready for us. Like I shared, besides Jordan joining me tonight, we also have Roland Wong, who is an amazing advocate with OCA National. He is a lecturer at the University of Michigan, as well as a co-founder of American Citizens for Justice. He's also the former Michigan Assistant Attorney General and serves as our national vice president on our executive council for OCA National. So really appreciate you being here, Roland, and guiding us through the discussion today. So without further ado, that's what we're going to do tonight for the next 50 minutes or so. So I'll kick it to you, Jordan, to kind of frame the discussion, and then we'll get right into it. Thanks for joining us, everyone.
Thank you, Bree. Good evening, everyone, and thank you all so much for being here. Before we move into our Q&A with Roland, I just wanted to briefly introduce what birthright citizenship is, what the current executive order is trying to do, how the litigation has unfolded so far, and why this issue should matter to all of us. To start, It helps to begin with the most basic question. What exactly is birthright citizenship? Uh, Birthright citizenship is the principle that most people born in this country are U.S. citizens at birth. It's grounded in the Citizenship Clause of the 14th Amendment, which says all persons born or naturalized in the U.S. and subject to the jurisdiction thereof are citizens of the U.S. The current executive order is arguing that some children born in the U.S. are not subject to the jurisdiction of the US if their parents were undocumented or only temporarily present. So, at the heart of the issue right now is a basic but extremely important question. Who counts as a citizen at birth and who gets to decide that? Now that we kind of have that foundation in mind, the next question is, how did this become such an urgent legal issue now? Well, on January 20th last year, President Trump signed Executive Order 14160 titled Protecting the Meaning and Value of American Citizenship. Then on January 21st, major lawsuits were filed challenging the order, including Casa versus Trump and a multi-state case led by Washington. In early 2025, uh, federal district courts issued broad preliminary injunctions blocking enforcement while the litigation moved forward. Then on June 27th, in Trump versus Casa, the Supreme Court ruled on the scope of nationwide injunctions. Importantly, the court did not decide whether the executive order itself was constitutional. Also on June 27th, after that ruling, advocates filed Barbara versus Trump, a nationwide class action in New Hampshire. On July 10th, 2025, the district court in Barbara versus Trump certified a class and issued a preliminary injunction blocking enforcement against that class. Then on December 5th, the Supreme Court granted review in Trump versus Barbara, and in a few days, just on April 1st, 2026 now, the Supreme Court is set to hear oral argument in Trump versus Barbara, which is now the case on the merits of the executive order. So, where things stand now is this: the court has already addressed the injunction question, but the major question still ahead is whether the executive order itself can legally stand. That is why April 1st is such an important date. That is why we have this webinar here today. And since there are several case names in this timeline, I'll pause here and sort out which lawsuits, give a brief overview of what lawsuits we should be paying attention to, and what each one actually did. First, Casa versus Trump. This challenge was brought by immigrant rights groups and affected families. It was one of the three cases the Supreme Court addressed in Trump versus Casa. But again, that ruling was about the scope of injunctions, not whether the executive order is constitutional. Second, Washington versus Trump. This was a multi-state challenge led by Washington and other states, and it was one of the three injunction cases before the court in Trump versus Casa. Third, New Jersey versus Trump. This was another multi-state challenge, also included in the Supreme Court's decision on the scope of the injunction. Fourth, Barbara versus Trump. This was the nationwide class action filed after the Trump versus Casa ruling. As mentioned earlier, the district court certified a class and issued a preliminary injunction, and the Supreme Court later granted review. It's now the main case on the merits of the executive order. And fifth, this is OCA's own lawsuit. It was filed in the U.S. District Court for the District of Columbia on January 30th, 2025 by OCA, AAJC, and the Washington Lawyers Committee. The case challenges the executive order as unconstitutional and argues that a president cannot override birthright citizenship through executive action. The clearest takeaway is that in Trump versus Casa, the Supreme Court addressed how broadly lower courts could block the executive order, not whether the order itself is constitutional. And the key case now on whether the order can legally stand is Trump versus Barbara. Finally, why does this all matter? This matters because birthright citizenship has long provided a clear and stable rule. If you are born here, you are recognized as belonging here. The executive order would break with that settled understanding by denying recognition of citizenship to some children born in the US. If allowed to stand, it would create confusion, separate families, and leave children growing up in the only country they have ever known without the security of full recognition. If allowed to stand, it would make something that has long been clear far more confusing for families, agencies, and courts. Um, and for immigrant communities, including many Asian American families, this is deeply personal. Many of our parents and grandparents came here hoping to build a more secure future for their children and their grandchildren. And birthright citizenship helped make that security possible. Some children now could face the risk of statelessness if they are denied US citizenship and cannot easily obtain another nationality. In other words, a child could be born here in the US and still be left without secure membership in any country. And this debate is often framed through fear, as though ending birthright citizenship would solve some larger problem, but in reality, it would definitely create new ones. It would leave more people born and raised here without secure status, and it would push uncertainty deeper into everyday life, in schools, in healthcare, in jobs, and in families trying to plan for the future. And ultimately, this is the last thing I'll say. This is about the rule of law. No president has the power to rewrite the Constitution or strip citizenship by executive order. So this debate is not only about immigration, it is about belonging, equality, and whether a long settled constitutional promise can be narrowed in a way that leaves families more vulnerable. Um, that's just a basic overview of the issue at hand tonight. And with that, I'd be happy to turn us to our conversation with Roland, which should really help us think more deeply about the legal, historical, and community stakes of this issue. As Bree mentioned, we'll have a Q&A after, so please feel free to leave any questions using the Q&A function as we move through tonight's webinar. And yeah, I'll hand it over to Bree and Roland now.
Yeah, thank you, Jordan, and thank you, Brianna. I think it's important to frame the debate starting with the 14th Amendment because, after all, that is probably the strongest card in the deck of cards. The 14th Amendment says all persons born or naturalized thereof and subject to the jurisdiction uh, is a U.S. citizen. And that is in the first section of the 14th Amendment. And that has been settled law ever since, 18, uh, the 1870s, late 1870s, during Reconstruction, where we were trying to, as a country, settle what the issue is with respect to who's a citizen. The aftermath of uh, the Dred Scott case, where going from one state to another would determine whether or not a uh, freed slave is subject to citizenship or might revert to not being a non-citizen, caused a civil war. And it's after the U.S. Civil War that during Reconstruction that the 14th Amendment was passed. And it's been settled law for since 1898, excuse me, with Wong Kim Ark and Luk Tin Singh in 1886, where the court has held that birthright citizenship is absolute, uh, subject to limited exceptions, i.e., subject to the jurisdiction of the United States. For the most part, that exception is for diplomats. You may know of other cases where diplomats in the United States have had traffic accidents or run into trouble with the law, and they assert diplomatic immunity. And that has been settled law in terms of diplomatic immunity. But the current administration is trying to expand that subject to jurisdiction to sort of an idea of consent, that the United States has to consent to someone's presence in the United States to have jurisdiction as a strict matter. Wong Kim Ark is very uh, reflective of actually what the law is under birthright citizenship. Uh, Wong Kim Ark uh, was the son of two Chinese subjects who were subject to the Emperor of China, and he was born on at 275 Sacramento Street in San Francisco, and he went back to China to visit his family, who had his parents had relocated back to China, and he tried to come back to the United States, and the inspector in San Francisco refused him entry under the banner of the Chinese Exclusion Act, claiming that this Chinese Exclusion Act somehow trumped the 14th Amendment. And under Wong Kim Ark's holding, he was a U.S. citizen by birthright, and really the Chinese Exclusion Act had no effect on that birthright as under the 14th Amendment. And that's been good law since 1898. It's been upheld by district courts, circuit courts, and court of appeals. And now, the Supreme Court decides to take it up to perhaps settle the question. The issue is what is subject to the jurisdiction of, um, and really it is by definition limited to diplomats and invading armies, which is not the categories in play in all of the litigation, Barbara and Casa, et cetera. Uh, the EO 14160 tries to carve out exceptions for mothers who are unlawfully present, um, and fathers who are not citizens or LPRs, uh, uh, limited residents, and so LPRs. And so the question is for mother's presence at birth, who's lawful but temporary. There are a lot of categories that could be implicated by this executive order. Uh, People who are subject to a visa waiver, students, graduate students who may spend years and years in education, higher education here, and people who are on work visas and even tourist visas. And so there's a whole bunch of mothers who are potentially affected by uh, a potential adverse holding if the Supreme Court decides to go this way. Uh, the executive order is 14160. It's at the Federal Register 90 FR 8449, which was entered on January 29th, 2025. And it's very instructive as to how corrosive that executive order is. It imposes the order that no department or agency of the United States shall issue documents recognizing citizenship, which is a very sweeping effort or action, and it takes effect 30 days after the order. But of course, that's been stayed by injunction. So if the Supreme Court was to rule in the administration's favor, uh, the ruling could take effect 30 days after uh, a Supreme Court order that says that the executive order is to be upheld. Section 3 calls for enforcement, and it bars the Secretary of State, the Attorney General, the Department of Homeland Security, and Social Security to deny those benefits that would be entitled to someone who is a U.S. citizen. And so potentially millions of people could be affected if there's an adverse holding. And so that is the ramification if the Supreme Court should decide that any part of the executive order is upheld. There are a lot of issues with respect to a lot of language that could be adopted by a sort of middle ground holding of the Supreme Court. It could be given effect for births farther down the road than 30 days after the order. It could be more limited with respect to certain categories that are in the executive order, like those people that are under a visa waiver or TPS, temporary protected status, students, graduate students, that sort of thing. It's just unfathomable how corrosive this is and how much people would be affected. Certainly, the graduate student population, there are hundreds of thousands of graduate students who are international students that could be affected, should they bear children, while they're here in the U.S. And so that's the area of concern. And I guess it's important to know that milestone, April 1st, 2026, to be in DC to witness the oral arguments and actually to, you know, tell the world what your position is with respect to the sanctity of birthright citizenship.
Amazing. Well, thank you so much, Roland, for kicking off our conversation with a really comprehensive overview of what's at stake with this SCOTUS hearing on April 1st and what's in the executive order, right, that we are challenged that that's going to be heard on April 1st. So you touched on a lot, and I have a few questions here to kind of get us going. So we'll see where the discussion goes. And like I said to the participants, if y'all have any questions, feel free to drop that in the chat that we can collect for Q&A. But Roland, you kind of touched on this before in terms of the corrosive effects, right, of this executive order and this challenges to birthright citizenship. So how do you believe, like, how might changes to birthright citizenship alter the systems that depend on clear citizenship status, such as public benefits, legal documentation, or just generally civic participation, right? And so what do those changes mean for how society is organized today? If there are changes to birthright citizenship in this country.
Well, birthright citizenship, has been the law in the United States for decades and decades, actually, over a century. And it's very definitive. Virtually 100% of the people know or can document where they were born. Certainly, in the United States, if they are born in a hospital or in a clinic or even at home with a midwife, there is the ability to document the occurrence of a birth happening on U.S. soil. Uh, that makes it very objective. The idea of uh, going to some other system, and there are other systems common in the world, uh, which is just sanguine, which is uh, birthright by lineage, is common in places like Japan or Italy or some, other places. I mean, it's not just unknown countries that have solely just sanguine as opposed to just solely, birthright on the soil. Uh, that would just create turmoil because it's a lot harder to delineate what your lineage is uh, as a matter of proof. And it really does call into question how certain can one be based upon that. Are you going to go to 23andMe or Ancestry.com or whatever? Uh, how far do you have to go to prove your birthright, I guess is the question, as opposed to the objective standard of, well, I was born here, born on U.S. soil. The whole idea, and I presume that the Supreme Court, if not directed, will go ahead and talk about the foundation of the 14th Amendment, which was an attempt during Reconstruction to deal with the freed slaves and how do you treat them, now that they've been freed of slavery, are they to be granted citizenship like, white residents under the Nationality Act of 1790? And the whole idea in the during Reconstruction was to have an objective standard that would withstand partisanship state by state. They were fearful that the southern states would revert back to some sort of mechanism that would disenfranchise Black Americans. Not to mention that Jim Crow laws did occur, but with the birthright citizenship clause, 14th Amendment, that effectively put a stop to any citizenship debate, although it didn't abolish Jim Crow. But it's also important to note that the legislative history, the congressional history, talks about the other people who were not likely to assimilate into America's culture, and that includes Chinese and the Gypsies, now called Romani, where they thought, oh, these people are not assimilable, and so there should be the idea that if they're not assimilable, they shouldn't be citizens. Well, Wong Kim Ark in that lawsuit, put a stop to that because it formalized and recognized birthright citizenship. So it's not just freed slaves that were at issue, but also Chinese Americans, Asians, and the Gypsies in Pennsylvania, et cetera. So uh, it's good law because it's very objective, and the Supreme Court should be reminded by all those briefs about the background of the atmosphere that happened during Civil War and during Reconstruction. So
Exactly. Yep. And I think, I think that's not lost on a lot of us in terms of how this also intersects with civic participation, right? The same narratives that administration is putting forward against birthright citizenship, defining who belongs in this country, right? Who should have power in this country. The same narratives that they're pushing to try to curtail or ban, eliminate birthright citizenship is the same narrative you're seeing right now with them trying to push things like the SAVE Act, which, OCA has also been vocal against, which is an attempt to pass a federal or law that would require eligible voters to prove citizenship, whether it be by providing a birth certificate, right, or by or a passport. And so I think when we think about these fights right now around the SCOTUS here on April 1st, the fight right now around the SAVE Act. It really gets to this question of, historically, how has this country reckoned with who gets to participate in our democracy and who gets to belong, right? And so I think that's an important thing that's also happening on the Hill, as well as as we get ready for the SCOTUS hearing. Roland, you touched on this
I
too,
should mention,
also. Yeah.
I should mention that uh, President Trump, when he was a candidate, said, "Oh, I'm not involved with Project 2025."
Mm-hmm.
But the fact is, everything that's being undertaken now is in Project 2025. So, he campaigned one way, but he's implementing everything that's in Project 2025, whether it's the
Mm-hmm.
overturning of Roe versus Wade, the reduction in voter access,
Mm-hmm.
whether it's purging voter rolls, uh, whatever. And now
To
birthright
challenging birthright
citizenship.
citizenship. Exactly.
Everything is under attack. So
Exactly, exactly. All our freedoms, right, are interconnected. So, you've talked a lot about the historical, right, significance of birthright citizenship and how it intersects with race and immigration status, especially impacting, Asian Americans from Ron Kim Ark. the 1952, right? Like immigration law. So I'm curious, how have past challenges to birthright citizenship reflected broader ideas about race and belonging? And in what ways today do current debates continue or depart from those patterns? And I think your thread just now on Project 2025 is a good segue there. But yeah, like what are some of the differences that we're seeing, right, in terms of the debates around birthright citizenship today that feels different or is different from what we saw in the past?
Well, I think this attack on birthright citizenship is part of a bigger pattern in terms of an attempt to change the impression or image of what it is to be an American, uh, i.e., if you do not look like what is the prototype American, then what are the ways where you could be excluded? Whether it's visa denials at the consulate
Hmm.
level in other countries, or not giving visas for people from 75 countries, or not extending seasonal work visas, or whatever. This is part of an overall, I think, plan. Uh, I think that's it in a
Right.
nutshell.
Yeah. And I guess tied to that too, right? In terms of the narrative. And I'm also curious if folks in the participants want to drop any things in the chat. But as we gear up for April 1st, right, with the SCOTUS hearing, how has the issue of birthright citizenship been framed in like media discourse or political discourse? And how do we think that is shaping the public understanding, or misunderstanding of the issue as we get into the hearings? As you mentioned, it's important for advocates in OCA and our allies to be vocal, right, about protecting birthright citizenship, by protecting this constitutional right. What are some maybe misinformation or ways that we're seeing media discourse right now talking about this upcoming SCOTUS hearing, and how is that impacting public's perception of what's at stake with birthright citizenship?
I think there are a lot of articles that are surfacing about birth tourism,
Mm,
and it has been brought up in past presidential campaigns about what to do about the birth trade, tourism that is based upon people wanting to give birth here in the U.S. as a way around, the system. And but I think if you look at the statistics, it's not going to make a numerical difference. And in fact, if someone is born in the U.S. of visitors to the U.S., they can't sponsor their parents under the second preference or
mm,
siblings under the third or fourth preference until they're 21 or maybe 18. But anyway, uh, it's a long time to wait if they're actually trying to gain citizenship for siblings or parents, that sort of thing. So I think it's really a red herring, but
hmm
it does come up. I mean, I've read a couple of articles in the Guardian and elsewhere about how prominent is uh, the birth the birth tourism trade, that sort of thing, which is sort of an
hmm
exception that they seem to pare it out. When this issue of birthright citizenship crops up.
Right. I'm curious, actually, I'm not sure if this is related, but that's either the narrative around, tourism or whatever. It's also kind of, I remember this coming up too during like Roe v. Wade, in the sense that there were some there was discussion there around, forced motherhood, right? And like with that, and I'm just curious if there's any intersection too in the discourse we saw in Roe v. Wade versus, potentially what's coming up with the birthright citizenship case. That might not be a question. That's more of an observation. Um, but yeah, so in terms of questions, I have one or two more for you, Roland. But for the participants, we're going to be entering Q&A soon. So if folks want to continue dropping questions in the chat, please continue to do so now so we can get them ready for the Q&A portion of the call. But as Jordan laid out for us, um, there's a bunch of lawsuits, right? So given the current lawsuits challenging the executive order, as a reminder to folks, and if folks joined late, the SCOTUS hearing coming up on Wednesday, April 1st, is not the OCA case. OCA is a plaintiff in a birthright citizenship case represented by Asian Americans Advancing Justice, AJC, and the Washington Lawyers Committee. So this is not our case, right? But we've submitted amicus briefs. But there's been a flurry of litigation, right, the past year since the executive order came out. So given the current lawsuits challenging the executive order, Roland, what are the most likely legal pathways forward? And what should communities and advocates be paying attention to in the coming months? I know there's been also a lot of discourse online about how poorly written the executive order is, right? And yeah, just curious how we should be paying attention to the different legal pathways coming up post-hearing.
I think the drafting of the EO, the executive order uh, 14160, was not very scholarly. And if you are an academic, you could probably pick it apart in terms of, well, what about this scenario? What about that scenario? It's not addressed, that sort of thing.
Hmm.
Uh, but I think the executive order hits the high points in terms of the groups that they want to affect, and mainly it's the mothers that are not legally present or undocumented, quote unquote, undocumented immigrants, that sort of thing. Uh, that's probably numerically the biggest group that would be the target. And but we have to be mindful of the other affected groups too, because that probably would uh, cause a pause or a reduction in the number of students coming from abroad, or affect work visas, that sort of thing.
Hmm. Right.
But of course, they have home countries as well, and so it would just be an administrative matter of, well, okay, they won't be U.S. citizens, but they will be, citizen of somewhere by lineage, for the most part.
Hmm. Right.
But
So as
a
we're thinking about,
complication, a
right,
complication.
for sure, complication as we're thinking about, right, like what does it actually mean in practice and who's going to be impacted? And so actually, this is a good segue to one of our audience questions. So we have about 15 minutes or so left in the webinar. So we're going to open up Q&A. So one of the questions from the audience, Roland, was, would the SCOTUS decision be retrospectively or prospectively applied in effect? So yeah, yeah, take with it as you will with that question.
Well, I think it could go either way. It could be 30 days from when the SCOTUS decision is adopted, if it adopts the executive order language, or it could just revert back to 30 days from the date of the executive order, which was what, January 29th, 2025. Who knows? I mean, it's up to the Supreme Court. I don't make decisions for the Supreme Court, probably up to them. Um, it's
Right.
probably up in the
Yes,
air.
I think so. I think something I think we'll see, right? Um, so in terms of another question from the audience, is there data on states' reactions to the executive order? So the executive order has been out for a year now or so. And if there isn't data, in this case, are there documented instances of states seeking to support or reject the issuance of a birth certificate? So I think what this question is getting at is how are the states reacting to the executive order? And has there been any public remarks by, leaders in different states to either challenge whatever decision is going to come down around birthright citizenship and how that impacts issuances of birth certificates? So how are the states reacting to this case coming up and to the executive order?
I think that that's a problematic area to the extent that immigration and the granting of citizenship is a federal act, not a state act. Typically, states do not uh, grant citizenship, but there are exceptions. One comes to mind, Begat Singh Thind in 1923. He was an individual who claimed to be of Aryan stock because he was high class Hindu. And after the Ozawa case, failed with respect to Takeo Ozawa seeking U.S. citizenship because he acted, in his view, American. He didn't speak Japanese in the home. He wasn't educated about Japanese culture, et cetera. But the court said, well, you can't
Mm,
act American, in order to be an American citizen. Uh, it turns out that Bhagat Singh, Singh Sindh, uh, Singh Thin, uh,
mhm,
was granted a citizenship locally by a clerk acting probably without knowledge of the federal, Supreme Court holding in 1923. And so um, I guess that could happen, that someone who is not knowledgeable about how the court acts can go ahead and issue, citizenship papers on. But and then what would be the legal effect of it down the road if that person goes to another jurisdiction, moves to a different jurisdiction, and then tries to claim benefits that are based upon citizenship?
mm,
They could be turned down when they move from one jurisdiction to the other. So that leads to a patchwork response. If it's like uh, miscegenation, pre-Loving
right.
versus Virginia, where some states had miscegenation laws and some didn't, and whether they move from one state to the other with or without miscegenation laws, it would affect your rights. I would envision that that might occur, but who
Hmm.
knows? It
Right.
depends on it depends on what the Supreme Court does with the executive order.
Hmm. And how much also like leeway, right, the Supreme Court does, if at all, on the executive order. Grants that, if at all. So another question kind of related to data that came up from the group. How many other countries have birthright citizenship, and how many countries do not have birthright citizenship? If we have that number top of mind.
Well, I don't have that number, but I know that just sanguini, which is
Hmm.
citizenship by lineage, is pretty common. And
Hmm.
actually, birthright citizenship is probably relatively rare. But
Yeah,
objectively speaking, it's a good way to manage your birth program, citizenship program, because it's so objective. But
right.
but
Well,
I
that's
don't have
that's
the
one
data.
thing. Yeah, yeah. And I mean too, that's one thing that we're seeing in terms of like the narrative around birthright citizenship, right? Is I think the folks that are challenging it are trying to contextualize it in the broader like um global context of which countries do have birthright citizenship, which ones don't. From my understanding, I think there's like about 30 countries, including the US, that do have birthright citizenship. So I do not know how many countries do not have birthright citizenship and follow the more lineage path, but there's about 30 of us, right? So it's not so uncommon. And I think another part of this narrative and reframing of birthright citizenship is even if, yes, people want to ask how many countries do or do not have birthright citizenship, we have this very specific context, right, with the 14th Amendment, the very specific context of how birthright citizenship and the freedoms that came out of Reconstruction, right, and came out of the abolition of slavery in the US, which is, again, very contextually important to distinguish the United States from maybe other countries abroad that do not have birthright citizenship. So that's another thing, part of the narrative framing too, to remind people about the historical significance, right, of what came out of birthright citizenship for the United States. Um, so yeah,
I should
another
mention
question. Oh, yeah.
I should mention that, you know, knowing history and what the country was coming out of in terms of a civil war and going through Reconstruction and passing the 14th Amendment was a sort of a healing process and was an attempt to settle the issue outside political contexts. That is, the southern states were going a certain way, the northern states would be going a certain way. Well, that is akin to what's going on now, to the extent that as we carve away constitutional rights, like in the Roe versus Wade context, that
Mm-hmm.
the country has created some schisms because of that, because of politiz politicization of the issues.
Right. Yeah, and it's exactly to your point, the 14th Amendment particularly, right? It was a healing moment for our democracy, right? In the sense that it was correcting the, wrongs of the Constitution in which we were naming, folks who were enslaved as three-fifths of a person, not guaranteeing them full personhood in the United States, let alone, but let's the 15th Amendment, right? When it's actually grant citizens to grant voting rights, right? For folks that are considered citizens in the US after the 14th Amendment and being freed. So another question that came up for folks, Roland, is how could the executive order impact, or I guess the impacts of this ruling, impact Asian children born in China or in Korea, adopted by US parents? Shortly after they were brought to the US, they were given US citizenship, although they were babies at the time, according to the person that raised this question. So, how would this impact, yeah, Asian children born in China or Korean adopted? So, how would the impact of birthright citizenship have on adoptees in the US coming in from those countries or have been here from these countries?
Well, there is the Citizenship Act of, I think it's, uh, was it maybe 2020? I don't remember the year, which uh, recognized uh, adoptees coming from abroad, uh, but whose parents did not go through the formal paperwork of going beyond the adoption and actually, allowing U.S. citizenship for the people kids they adopt. That was partially corrected, but it was not fully comprehensive. So people
Mm-hmm.
like Adam Capsers, who got deported, uh, it didn't go back as far as the situation for Adam Capsers. But there are bills that are pending now to correct that, to move the needle farther back. Uh, so that's a statutory solution,
Mm-hmm.
um, as opposed to what's in hand, 14th Amendment.
Right. Thank you for addressing that, Roland. It seems like there's another question here, a bit more personal, so I appreciate the person that asked this question. Um, One of my friends from China has a 7-year-old child born in the US. The child's grandmother is planning to take her back to China for the summertime and return her in the fall for school in the US. Is this child at risk for reentry?
I would think not if that child was born in the U.S. You know,
Mm, right.
there's no retroactive effect for this executive order 14160. It says 30 days after the writing of the executive order, but it doesn't apply to someone who was born before that.
Mm-hmm.
Um, there are other categories of people who travel back and forth who are under visas, and I know of situations where their visitor visas or temporary visas have been revoked um, when they go back to China and then try to come back on the same
Mm-hmm.
R visa, and it's been revoked. Same thing for OPT visas, where they used to be renewed routinely, so the person could continue working. Uh, our bilingual social worker at
Mm-hmm.
OCA Detroit, you know, went through the OPT renewal process. But then once they said, no, we're going to give it a stricter scrutiny. We're not just going to give it an easy okay. Well, he was forced to go back to the PRC. So rules can change, and that certainly changed, for that individual. So I'd be wary about traveling.
Mm-hmm. Right. I think it's fair. That's a fair assessment. This is a great question. And also I know Jordan gave a great presentation on this earlier. So folks who are not on early in the webinar, we gave a presentation of kind of the lawsuits and the legal landscape that this upcoming SCOTUS hearing on April 1st is existing in. So this question from, I believe, from participant In addition to OCA, what other groups are contesting the legality of the executive order and what groups are in support? So I'm not sure, Roland, if you would adjust to that, or Jordan, I know that you also gave a great presentation, so curious if y'all would want to lay that out for our participants.
I've got a list with uh, maybe 100 organizations that are participants in this birthright citizenship debate. Uh, the Asian Law Caucus actually had a webinar just a couple of hours earlier, and they put on the screen the list of all the supportive organizations. And it was dozens. So,
Yeah,
um,
dozens.
and I don't know if I have it within arm's reach, but it's quite a comprehensive list.
Right. And as a reminder to folks, again, this April 1st hearing is on our case, but OCA is a plaintiff in a birthright citizenship case represented by Asian Americans Advancing Justice, so AJC, and the Washington Lawyers Committee. So they're with us in this challenge to the executive order. And most recently, OCA joined a bunch of other immigrant advocacy groups filing an amicus brief in this landmark Supreme Court case challenging the executive order on birthright citizenship. So I believe the groups that worked with us on the amicus brief included organizations like Make the Road New York, ASAP, the Asylum Seeker Advocacy Project, LULAC, We Are CASA, and maybe there's some others. But I believe those are the groups that we signed on to this amicus brief, reinstating our position, right, on this upcoming hearing. Okay, great. So I know we might only have a few more minutes left. So let me see if there's any other juicy questions in the chat. Let's see. Okay, maybe just one more for tonight. And if anyone has any other burning questions, this is probably your last call to drop them in the Q&A or in the chat. But I believe this was touched on earlier, Roland. But again, as we're thinking about what's coming up on April 1st, this participant is asking, given the feedback received on the executive order, what happens if the court decides to revise or if it becomes more legally restrictive? That is the question.
That's, I guess, speculative. I mean, to
Yeah,
the extent that we have to wait and see what the court rules and then react accordingly, I guess.
yeah, I
I'm
think that's
sure
right as
there
well.
are categories of individuals that were not covered by particular litigation, and that would be an invitation to seek clarification, to cover those groups.
Mm-hmm, mm-hmm. Yeah, I believe that's right. Amazing. Well, I really appreciate everyone here for dropping some really great questions in the chat. I hope this was helpful. Thank you so much, Roland, for engaging in this discussion with me. I learned a lot, as always, whenever I hear you speak about birthright citizenship and all the different Supreme Court cases. In terms of next steps, and yeah, Jordan, feel free to join me and getting the group excited about what's coming up. Um, as a reminder, y'all, the April 1st is the day, Wednesday, April 1st is the day of the SCOTUS hearing. There will be a rally happening in front of the Supreme Court. So if you are in New York, for example, or in the kind of Northeast region, I believe we are chartering a bus to get folks from New York to DC. And if you are in the the DMV area, we really encourage you to join us out there on April 1st as we rally and we make our voices known that we stand with our communities and that we want to protect birthright citizenship. But there's other things you can do if you're not in DC, right? So in the chat, Jordan just dropped 3 helpful resources on birthright citizenship from the Asian Law Caucus. So if you're not in DC or you can't come down to DC April 1st, you can still get involved, write op-eds, write letters to the editor, work with your OCA chapters to continue educating our community members about what's at stake and what's important about this upcoming SCOTUS hearing. And definitely stay tuned. OCA National will be sending out more calls to action of ways that y'all can get involved and continue to organize around birthright citizenship. But again, I encourage if you are able, to come to join us in DC, please, we would love that. Anything that I'm missing, Roland or Jordan, in terms of calls to action or next steps for folks? Yeah, anything else you would add?
You covered it. I think you covered it.
Okay,
Thanks,
great.
Bree.
Awesome. Well, thank you so much, everyone. I hope you all ended right on time, 9 o'clock, which is amazing. Thank you again, Roland. Thank you, Jordan. Thank you,
Thank
OCA
you.
national team, and we'll see y'all in DC, or across the country. Bye.
Bye now.
Yes, the resources I believe will be shared in the email if you register tonight. Great. Bye.
Thanks.